topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio, its employees, or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Orlando. Welcome to another Ask the Expert show, where for the last 16 years, starting next month, it's going to be 17 years, we have brought you the finest experts in the field of legal, health, financial, and home improvement. Hey, this is an exciting show. This is our first TikTok live show, and I couldn't have started off with a better expert. The K. Bender Rimbaum law firm, community association firm. If you live in a condo or an HOA, we have got the greatest attorney that will be answering your questions. Let me introduce you to my buddy, board certified attorney, Alan Swartzside. Have you gotten used to that yet?
You know what? It's coming up on... is it a year or 2 years? Whatever it is, I'm getting used to it, but I will tell you what I'm not yet used to is the new title of TikTok star. I'm pretty excited about that. I appreciate it. My daughter's going to be more excited than I am, but I'll take it.
I hear you. I hear you. And they're going to be doing snippets from the show throughout the day. This is really exciting. But you know what? We don't need TikTok because your show is kicking butt. I mean, we're on YouTube, we're on Facebook, we're on iHeart, and we've got the greatest producer in Juan Garcia. But what really makes the show, Alan, all these people who send their letters in, and I mean, it's amazing. I get blown away every month that, God, we got 20, 25 letters. People know your show's coming on. And we could never do a Stump Allen show. You've always got an answer for everybody.
Well, here's the thing. You could, but it'd have to be unrelated to representing community associations.
Okay. That's a good comeback.
You asked me about basketball statistics, and my son's going to win that challenge. I'm not winning that.
I got you. Did you used to live in South Florida, Alan?
I did for a while. Actually worked with the firm for 4 years while I was down there. I was in Boca Raton and was in Plantation for almost a decade. From the time I was 12 until 2018, I was down in South Florida and then moved up here to Central Florida into Winter Springs, now living in Oviedo and working in Winter Springs, starting in 2018. So yeah, I mean, I spent a lot of time in South Florida, which is how I connected with the firm. Was there doing nothing but collection for 4 years and moved around a little bit in the interim. But about 4 years ago, decided, you know what? I think I'm ready to come back. And here we are.
Well, again, because of TikTok, and I'm seeing all these people who are joining into the show. This is our community association show. This firm covers all of Florida. And if you live in a HOA or a condo association and you've had a question that you always wanted to ask an attorney, we have the finest law firm, K. Bender Rimbaum, throughout the state of Florida. You've got 4 offices, right?
Yeah. So we've got me here in the Orlando, Central Florida area, covering pretty much everything straight up north to the end of the state. Kirsten manages our Tampa office. We've got Palm Beach Gardens, which is managed by Jeff Rembaum, and Robert Kay and Mike Bender host and manage our Pompano office. So we're all over the state. We've got 2 South Florida offices, 1 West, me in the center of the state. But, again, you're absolutely right. We cover pretty much any community that needs help, and it's all we do.
Well, I got to tell you, I wish you could see my cell phone right now, all the people who are joining in for the show. And what we do is we have listeners and viewers who write their questions in every month. This show here is the last Thursday of the month at 5 p.m. Eastern time, and we are going to be asking questions. I learned this, do this show about 25 years ago when they had I was in Dallas and they had a show called Ask the General Manager. It wasn't a sports team. It was the general manager of the TV station. So let's get started. I've got a ton of questions here. The first one is Ronald in Orlando. He wants to know, can I really record a financial community association meeting when providing advance notice to the board and the management? I was giving a legal letter telling me this was illegal as it is not a board meeting.
I mean, member meetings and board meetings, the answer is a clear yes. The financial meetings, I don't know what a financial meeting is because that doesn't really exist under the Florida statutes. So unless it's some meeting that frankly shouldn't be held, it could be a meeting where there's a recommendation being made to the board. That would be something that you can record because it's subject to the same restrictions. But if it's some committee, you might not have the ability to record that meeting if it is not a committee that is making recommendations to the board regarding how to spend money. I just don't know what a financial meeting is because frankly, it's just not something that exists under the Florida statutes. So you might want to look into why the financial committee exists, whether there's a charter or something that says what they have the authority and responsibility to do, and take a look, and that will dictate the answer whether you're allowed to record that meeting or not. But again, generally speaking, the board can't stop you from recording any board meeting or member meeting unless the way that you're doing it is interfering with the way the meeting's being conducted, interfering with others' ability to observe what's going on, or if the board has a policy of requiring, and again, that policy has to be somewhere in writing, that you need to let whatever the governing body is know in advance of the meeting that you intend to record. They might be able to restrict it in that manner if you don't let them know in advance. But the reality is, generally speaking, you have the right to record most meetings. I just can't tell you because I don't know what a financial meeting is.
Yeah, I've never heard that.
A lack of knowledge. It's just not something that's in the Florida statutes.
I take it COA is community association.
Usually,
is that
yes.
Correct?
It could be. A lot of people refer to a COA as a condo owners association.
Condo association. Okay. Because I've never seen that either. Just so you know, I'm not trying to use this show as a guinea pig. I'm seeing all these people wanting to be invited on the show. I haven't learned how to do that yet. I'll be learning that this weekend. This is literally our first show, but I see all the people who are wanting to join the show, which is amazing. Let's go to Craig in Orlando.
Okay.
Wants to know, in a condo with the declarations that prohibit corporate ownership, how is it best to address finding that several units are under corporate ownership, such as a LLC?
I mean, candidly, I'm not entirely certain that refusal to allow for corporate ownership is even enforceable. To the extent that it is, you would have to look at that particular declaration to see what it says happens in the event that a corporation becomes the owner. It could be that the association has the option, meaning it's voidable, to say that transaction is like it never occurred and ownership reverts back to the old owner. It could be that it's void, meaning that it automatically reverts back to the old owner, or it could be silent, in which case it's kind of up to the board to decide how they want to deal with it. But again, unless I candidly don't know that provision is actually enforceable, that you can say no corporation can own property. There are plenty of things you can do to say that investors are subject to certain rules, but it's not they're subject to rules as investors or as corporations. It's just that the rule applies to everyone, and it might address investors or might have a different result on an investor because, for example, they can't rent the property for 2 years, but neither can anyone else. So again, I'm just not certain, frankly, that provision is even enforceable to say you can't have a corporate owner. But let's presume that it is. It's just a matter of what does the declaration say happens if someone that's not supposed to own a unit ends up owning a unit.
Okay, we're going to go to Sissy in Orlando.
Yep.
Practicing law without a license was the claim of the condo association attorney to an owner who simply cited state statutes with regards to requirements for 75% vote of the owner's retaliation.
Okay. I'm going to try and glean a question from that. So
Actually,
I'm going to presume that the question is it the unauthorized practice of law to quote a statute back to the association? To the extent that you're trying to represent the entire membership, yeah, it probably is. To the extent you're representing yourself as an individual homeowner, no, it's not. You're representing yourself. So I would not necessarily agree with the attorney saying it's the unauthorized practice of law. If you're allowed to walk in a court and say it, there's no reason you can't say it in an open meeting. Whether that's considered retaliation, no, it's an attorney telling you that you're not allowed to do what you're doing. I wouldn't call that retaliation. I would call that a response to an act that attorney feels is not allowed by Florida law. If you're sitting there and saying that an amendment, which I presume to be what you're talking about, or maybe a material alteration, is going to require a 75% member vote, that's your opinion. They can disagree with it, but that doesn't make it your legal opinion that is the unauthorized practice of law. If you're saying that representing other unit owners and you're not a lawyer, then yeah, it's probably UPL. What you might want to do is contact the Florida Bar and ask them about their opinion of whether this would qualify as the unauthorized practice of law. Because if they say no, then you can just tell this person, well, the people that would be prosecuting this if it was UPL have told me that they won't. So maybe drop it.
Hey, I want people in the chat line want to know if you will be answering questions from the chat line. Yes, so please write your questions in. We will be answering those also. Hey, the show it's a 50-minute show. We've got plenty of time, so write your questions in for Alan. Alan, we get a lot of people talking about a second car, and we had a policeman who wrote us, and he brings his police car on property, and they're telling him he can only have one car on property. Can the board actually do that to him?
Well, I mean, yeah, the reality is that if the rules say you can only have one car on the property, then unless you've got, I don't know if this is a condo or HOA, there is a statute in HOAs that talks about parking police vehicles in certain ways. But if this is a condo, that statute doesn't apply. And I mean, there's nothing that says that a police vehicle must be permitted on association property. It would be that, my suggestion is park that vehicle in the way that vehicles are allowed to park. I mean, the association in an HOA can't tell you you're not allowed to park your police vehicle in the spot that you've been allotted. But in the example being given, it sounds like they're only allotted one spot and they're using two, which, generally not a problem unless the governing documents say you're not allowed to do it, or the parking regulations that are supported by the governing documents say you're not allowed to do it. So, I mean, I'm never going to be the attorney that chooses to enforce that restriction against someone who's protecting the community as a whole. But that doesn't mean that there aren't others, especially the board, the manager, who might see that as selective enforcement. If the officer is allowed to do this and the rest of the members are not, unfortunately, my shorter answer is, yeah, the association's probably going to be permitted to do that if they have valid restrictions that say you can't park a second vehicle on property.
You have the greatest answer, because we get a lot of people saying, I'm so upset because assessments are so high. Why are they redoing the golf course? Why are they putting up new signs? And you and I have discussed this before.
Yeah.
Because actually your in-laws live in the same unit that a good friend of mine lives in, and she's been complaining about it. Tell people why it is so important that they make these changes, whether it's a golf course, restaurants, whatever the case is.
Yeah, I mean, it's actually my folks that live there, and it's the discussion we had, I don't know, it was almost a year ago now, was that they were redoing all the golf courses, they were redoing the fountain up front, and people are complaining, understandably, because it's a lot of money, and who pays for all these changes to be made? It's the members. But the reality is, in a community like a golf club or a tennis club or any country club, frankly, any community, you got to remain competitive with the surrounding communities. So if you're sitting there and saying, well, it's going to cost a lot of money, we really don't want our members to pay a bunch of money to redo this golf course that hasn't been redone in 30 years, then you're going to be sitting there and not be competitive with the other clubs in the area. Now, let's say you're not in a country club and it's just, they're redoing the sign and it's going to cost $5,000 and we don't want to have to pay our proportionate share. I totally understand that. I don't want my assessments going up either. And there are plenty of people in Florida that are on a fixed income and can't afford to have their assessments go up. But the reality is the declaration almost inevitably says that the board has the obligation to maintain these areas. And if they start to look like crap and the board doesn't do anything about it, then you'll have the members complaining that it doesn't look good. If they do something about it, you'll have the members complaining that they're paying too much for their assessments. I mean, these are volunteers that are just doing their best. Many board members are not actually business people. They're just people that care enough about their communities to actually volunteer their time to run a business. Unfortunately, that business requires that those directors actually go back and look around and say, what do we need to maintain? What do we need to clean up? What can we do better? What do we need to do better in accordance with our governing documents? Because if they don't do what needs to be done, then they end up with huge special assessments because, for example, instead of updating that monument sign at the front of the community, now you need to build a new one because it crumbled. Or instead of, going and taking care of the balconies when it would have cost $5,000 per, you end up with a special assessment that isn't part of the budget that costs every one of the members $100,000 because you put it off for 15 years. And now the cost has skyrocketed, not only because of inflation, but because the situation's gotten even worse gradually over time. So the bottom line is, I totally understand. I don't want my assessments going up either. But, I won't say smart enough, but I was knowledgeable enough is the way that I'll put it, to live in a community that's a 12-lot community. It's one street. So the only things we really maintain are the road and one other aspect of the community. But when that road started to get potholes, I wanted it fixed. I didn't want to pay for it, but I understood if it's going to be fixed and I don't want my car to also get destroyed,
right,
we got to pay to repave the road. So that's just one example, but the monument sign, the roof, whatever might have a problem, the board has the legal obligation to make sure that it gets repaired and maintained. And that's the reason these things go up, even in a community where you're not just trying to compete with your neighbors for people to buy in and for the club to have value to be a member.
We have here in Florida, we have open carry now. And I'm surprised we haven't gotten any questions about open carry, but we just got one that says, if an association tries to ban legally carried weapons on community property, are they then required to provide?
Steve, you froze up and I can't see the question, but I can take a good guess as to what it might have been. And essentially, if the association is going to create regulations surrounding whether firearms are or aren't allowed on community property, then, you can't restrict someone from having it in their home, from transporting it in a safe. But you can say you're not allowed to have it open or concealed on community property. The issue with having a sign or having a rule that says concealed carry is not allowed on community property is that it's concealed. That's the whole point. So you wouldn't know either way. You shouldn't know whether there's a violation or not unless someone pulls out a pistol in the middle of a board meeting. So that one becomes a little harder to enforce. Now, I don't know if it was, are you required to have a police presence, or are you required to do something else? Because Steve, you did cut out. I'm glad you're back now. But the bottom line is these are very difficult policies to enforce, because the enforcement mechanism, hopefully, if you're smart, is not going to be to go over to someone and say, hey, that pistol I'm pointing to, you need to bring it back to your house or your car. It's going to be to call the police, because you're not going to confront someone about their gun. If you do, that's on you, and I certainly wouldn't recommend it. But that's the problem, is policing it. It's basically, if it's a violation, you call the police and then you send a violation notice. It's not an easy enforcement mechanism. And what are you going to do to prove that someone was carrying? Take a picture of their gun on their hip or at their waist? I know that a lot of communities want to create these policies, especially because there are so many people that are frightened of firearms in Florida. But the reality is also that enforcing it becomes extremely difficult sometimes. And the problem there is that you end up with people saying, well, they're not enforcing that. And they think that they'll have a selective enforcement defense when they then go and put a shed on their property, even though it's completely unrelated, one violation and the other. People just presume, oh, it's selective enforcement. They didn't go after this guy for doing this, so I can do whatever I want. It doesn't work that way. That doesn't mean people understand it. So it's just, again, I'm not saying don't set that policy. You can control whether people are permitted to have firearms on private property. If you have that policy and someone is found in violation, they can be trespassed from that area. But you can't tell someone they're not allowed to get to their home.
Out. Let me see if.
All right, Steve, welcome back.
This, I don't know if it's from all the traffic on TikTok or not, but I want on a follow-up question. Then we're going to go to break. That they wanted to know. He didn't hear. Are they then required to provide armed security having disarmed members?
No, the only obligation to provide armed security, well, let me rephrase. There is never an obligation of the association to provide armed security. You should have security systems in place like cameras, lighting. There was actually a statute that came out primarily pertaining to apartment complexes a couple years ago that exempts the association or exempts apartment complexes from certain negligence claims if they do a whole bunch of things. Those are the things that you would want to do to protect the association. But no, there's no obligation. You aren't disarming the public. You aren't disarming the members. You're telling them that if they're in that specific area, the common areas of the community, they can't be carrying. That doesn't mean they can't do it once they get off campus, so to speak. It doesn't mean they can't do it on their own property. It just means that when they're going into the clubhouse, they're not allowed to carry. Now, to the extent that someone feels that creates inherent liability, it's a bad guy with a gun. There's nothing the association can do to control that because there's already a policy. Hopefully, it doesn't matter whether it's one of the members or some bad guy that comes onto the property. They're going to enforce it equally and try and avoid any firearms being on common areas. Whether the association enforces that across the board or not, it's up to the board. I would recommend either not adopting that kind of rule at all or truly enforcing it against everyone.
We're going to go to our break. We're here with board certified attorney Alan Swartzide, K. Bender Rimbaum. This is our first TikTok show. People are asking to come on, and I listen. This is kind of a guinea pig, but I couldn't have done it with a better firm. We've got such a large audience for the K. Bender Rimbaum show, where people can learn about community association law, if they're in a condo or if they're in an HOA. We're going to go to break. Alan, tell people how they can reach your office.
Well, they can email me at any time, as@kbrlegal.com. That's always going to be the easiest way to reach me. But if you want to reach literally anyone in the entire firm, the 1-800 number is 800-974-0680. Again, 800-974-0680. That'll reach anyone in the entire office, coming through our Pompano office into all the other offices.
We're going to go to a break. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the Ask the Expert show. We've been airing our show for 16 years throughout the country. Today is our Orlando, Florida show. We have one of the top community association law firms for Florida. So if you live in an HOA or a condo association, you've always had a question, you can now actually go on TikTok. And looks like a lot of people are on TikTok who actually want to come on. We actually will not be doing that, at least for right now, but we will take your questions. If you've got a question for the show, we're also on iHeart, we're on Facebook, we're on YouTube. You can actually watch us live on YouTube right now. We're here with one of the greatest community association lawyers, board certified, Alan Swartzide. He takes every month, the last Tuesday of the month at 5 o'clock Eastern time, he takes your questions, and we have got a ton of questions. We're going to go to Eric in Orlando. He wants to know, are the annual meeting quorum requirements also applicable to condos? No business should be held.
So I think I'm understanding the question to be the distinction between whether you've had a quorum or you've reached the 20% threshold required to have an election and what happens in each instance. So when you have the 20% that's required, 20% of your members show up, vote. Doesn't matter how they vote, they show up, they vote. Okay. Now you can have your election during your annual meeting or in conjunction with your annual meeting. That's completely separate from whether you have a quorum, meaning you can conduct any other business of the association. And a lot of times you've got a 20% threshold to have the election, but your quorum is 50%. I literally just had this come up in one of my communities earlier this week, and frankly, it creates a nice big mess. If you've met the threshold to have the election, you need to have the election, but how do you do that when you can't have a meeting? There's really no right answer or wrong answer. My suggestion is, since the statute says you can have the election if you have at least 20% of the members show up and vote, just have your election, but you might have an awkward method of announcing what the result is and having the directors seated, because technically that should be done at a member meeting, and if you don't have your quorum, you can't hold one. So it does create a little bit of uncertainty and awkwardness. That's one of those, once you've figured out where you stand, just run it by your attorney, because I can give you suggestions, but your attorney is the one that you're allowed to rely on, not me. Unless I'm your attorney, in which case, call me separately.
Michael in Orlando wants to know, I know HOAs have mediation, but do condos also offer mediation? So I suspect this is talking about pre-suit mediation for certain disputes. And the answer is yes. In an HOA, it's mandatory to go to pre-suit mediation, or at least offer to participate in pre-suit mediation before you file your lawsuit. That's covenant enforcement and a couple other types of disputes. In a condo, until recently, there was no pre-suit mediation. I think it was 24 or maybe even 23 that the legislature added the option to either go to pre-suit arbitration, which could be binding or non-binding, or go to pre-suit mediation. My suggestion, pre-suit mediation, you get to control your own fate rather than having some government official that does these arbitrations decide your fate for you. So my preference is always going to be mediation, because I'd rather see my clients get to decide what the outcome is. And if they don't like what the other side says in the mediation and there's no settlement, you get to go straight to litigation rather than going through the arbitration process, hoping it plays out in your favor, and then filing your lawsuit later if you don't agree. Yes. Something in the air today, Owen.
Well, you know what? Great timing, Steve. You popped back in just as I was finishing the answer.
Perfect. Let's go to our next question. This is from Jerry in Winter Park, Florida. Is it legal for a board member to not own property in the HOA? And can spouses serve on the same HOA board, or is that a conflict of interest?
So not necessarily a conflict of interest, because all of the directors are supposed to vote in favor of what they reasonably believe to be in the best interest of the association. So both spouses would have that same obligation to the association. I don't really see a conflict of interest there, but there are statutes that talk about whether spouses can serve together, what the conditions are that would allow that to happen or disallow it to happen. So you're going to want, I don't know if this is I think he said it was an HOA. I would just take a look at the statutes governing your community regarding who can serve on the board. Now, as to the original question, whether someone needs to own a lot in an HOA or own a unit in a condo in order to serve on the board, that's going to be governed by your articles of incorporation or your bylaws. Usually those will specify directors shall be members or directors need not be members. Just going to depend on what you're looking at. It's going to depend on what your governing documents say as to whether or not, I won't use the phrase whether it's legal or not, but whether or not you are allowed to have people that are not members of your community serving on the board. So, there is a statute that governs whether spouses can serve on the board. It'd just be a matter of taking a look at that statute and deciding how it applies to your community. Now, Steve has stepped out for a moment. I guess his connection is even wonkier than we thought. So I'm going to go through, if I can find them, some of the questions that people had submitted that he sent over to me earlier so that we can get some answers going for you instead of just having dead air, because we don't like that. So Lori in Sanford asks, can homeowners sue their HOA board for spending money on property that the HOA doesn't own? Yes, that doesn't mean they'll win. You can sue anyone for anything. That doesn't mean that you've got a valid claim. So as to whether there's a valid claim there, spending money on property the HOA doesn't own, it depends whether, if you're talking about suing the board, you need to find a breach of fiduciary duty, which means this needs to have been done with some kind of malicious intent. If there's no malicious intent and there's nothing that, was a major damage to the association, probably not a claim against individual directors. That doesn't mean, though, that you don't have a claim against the association for spending that money in a manner that it shouldn't have been spent. The question is, do you have that right? Or is it something that requires what's called a derivative lawsuit? Basically, you acting on behalf of all the owners as a class. There are a lot of different things to factor in. Frankly, that's not something I would suggest going after the board or directors or the association for, Lori. I would just try, if you believe that this was done improperly, to get these people removed from the board, or look into it more deeply. You might find that it actually did benefit the association. Steve, we just moved on to Lori's question in Sanford, so I'll turn it back over to you. I don't like hosting myself. I appreciate you coming back.
You're doing good. Alan, we get a lot of questions about doorbell cameras and people wanting to know if they install them, if that's a material alteration or not. Can you talk on that?
Yeah, I mean, if there was already camera there, whether it's a material alteration, it might be. But if the cameras are being installed to protect the community, then there is an exception to the requirement for a material alteration vote by the members, which I presume to be the real basis for the question. There is an exception in Florida case law that basically says if it's part of your maintenance obligations or it's more protective for the association, you really don't need that material alteration vote. So that's something, if it's the association looking to do it, I would run it by council. If it's the owners looking to challenge the installation, as long as they're not pointing inside a window or a unit, they're not pointing to your door in a way that'll see inside your unit when it's open, generally speaking, not something that you're going to be able to do a whole lot about. I would make sure that the board is getting advice of counsel to rely on before going ahead and just putting up a bunch of cameras, because there may be an obligation to put up signage along with the cameras and things of that nature.
Here is Beth in Winter Park. My board forced us to change our doors with no vote on the type of door and never set a process to get new keys. Our board president also has control of the keys they do have, and security has no access to them. I don't know if that's a question or not.
Yeah, I didn't hear a question, but it would depend as to whether they can require new doors. Was it more protective? Was there some specific reason why the doors were changed? As to the keys not having been given to it, it sounded originally like the keys weren't even given to the owners, but it sounds more like the keys were given to the president instead of management or security. I suggest that the board, the president might be, if the president lives in the community, it might be just as well that they have those keys versus security having them. But I agree with the suggestion that management or security having them in case the president's not there and having them in one location that's actually accessible is probably a better call overall. But, to the extent that the question, if one can be gleaned from this, is, is this illegal? No, not that I can tell, other than perhaps a material alteration without a member vote. But I don't know if Beth is in an HOA that doesn't require material alteration votes, or she's in a condo that might require one. So sorry, I can't give a better answer on that.
Okay, let's go to Craig in Winter Park. Can an HOA refuse or delay access to documents like the bylaws, government docs, or HOA financial records? And can homeowners request an independent audit?
The short answer is no. The association can't refuse access to the governing documents or the financial records. There is a statute that says the board has 5 business days from receipt of a request. Now, if the association has a policy that governs how those requests need to be submitted, that might be the basis to kind of disregard that type of request. But if it was submitted in the right manner, or if there's no policy governing how it needs to be submitted, the association has 10 business days from receipt of that request in writing to actually provide an inspection and copying of those records. If they don't, then technically there is a violation, and they owe what's called I call it the $500 gift. In reality, it's $50 in statutory damages per calendar day, up to 10 days, starting with business day 11, plus attorney's fees and costs if you end up having to, sue the association to get access to these records. Now, the other thing I'll point out is, instead of fight with your association, your bylaws, your declaration, your articles, usually they're accessible in the county records instead of battling back and forth, unless you're trying to set the association up for something. The financial records, that you definitely would need to get from the association, and they should be producing those records within 10 business days. Now, the homeowners can request an independent audit. You'd need to get the required percentage, which is either 10 or 20% or whatever percentage is listed in your governing documents, depending whether you're an HOA or a condo. But you can require that the association increase. That would be, you can require that they increase the level of financial reporting. That would require, again, the 10 or 20% or whatever's in your governing documents. That's to schedule a meeting to discuss, and then I think it's a majority of the members, not a majority of just those that show up, needs to vote and say we want a higher reporting requirement. So instead of having what we call a cash receipts and expenditures report, which is basically a ledger, you can say we want to up that. We want a more detailed audit. Now, to get an actual audit, if you wouldn't be required to do that and there's no vote, you can pay for it yourself, but you'd have to literally get every single official record of the association. The problem with trying to do that as an individual is that there's an entire list of documents that are not subject to that type of inspection by a member. So it really needs to be the association that's going to do an audit if it's truly going to be complete.
We're going to go over to the chat line on YouTube.
Okay.
MH is an HOA that is required to do an audited financial year-end statements over 1,000 parcels, also required to post those audited financial statements?
I mean, the short answer is it's the same requirement regardless of the size of the community. It's the same requirement regardless of what reporting level you're required to do. So the shorter answer is yes, the association needs to share that with the members. It doesn't necessarily need to be mailed to each owner or anything like that, but it's the same requirement that within, if you're in an HOA, I think was the answer. If you're getting an audit, that would mean you have up to 120 days from the end of the fiscal year to get that completed and report back to the owners that a copy is available upon request. Now, you can alternatively send a copy to everyone, but an audit is usually a pretty long document. So it might be a lot of pages, meaning a lot of dollars that you're spending to get that mailer out versus realistically a business card or postcard size piece of paper that says, hey, an audit is done. You can come, inspect it upon request. So the inspection option is usually going to be far less costly and the one that most people use.
Let's go to SG. How can an HOA enforce fumigation of a townhouse building? Is it recommended by a pest control company? The HOA is only responsible for the exterior walls, roof, and foundation.
Well, the answer would depend whether there's pest-related damage being done or potentially being done to those specific areas that you mentioned as being an association responsibility. If there are termites and their only responsibility is the exterior of the building, but the exterior of the building's wood, well, then, yeah, you can fumigate and get rid of those termites and clear out whatever problems you have and fix it. If we're talking about rats that are only in one of the townhomes and haven't bored into the wall yet, yeah, you probably wouldn't be able to fumigate as an association. It might be the owner's responsibility. But, generally speaking, the association most likely has the authority in its declaration to actually do whatever maintenance is necessary. And if that includes fumigation and removing everyone from the property for a couple hours to a day, then that might be something that they have the authority to do. How do you enforce it? You basically tell everyone, get the hell out. It's not going to be safe to be here from the times of X to Y. Now, if it's the question instead, because the question was, how do you enforce it? If the question was, how do we force the association to actually do this when it's required? Well, you send a demand, and if they choose not to, you basically have a potential property damage claim, and you look for an attorney that deals with suing associations. And eventually that might be what's necessary.
I've never heard of a turnover election. What is that?
So a turnover election is essentially when you've got the developer that's been in power because they created the community or they were transferred the developer rights and they're acting as though they created the community. And eventually either they sell enough lots or units that they have to transfer control, or some other event occurs that's statutory or under the declaration that says the transfer of power from the developer to the actual end users, the unit owners, the lot owners, needs to happen when this happens. And you have that election. It's basically, hey, we're giving up our control over the community. We're saying as a developer that the members are now in control. And there's also certain documentation and certain property that within a certain amount of time, it's 90 days in a condo or an HOA, the developer also needs to turn over those records and property to the association so that the members truly get, here's what's going on, and they get to control the association going forward. Now, keep in mind, there are also things that you can only do within a certain time frame after that turnover occurs. So when it happens, you need to make sure that your association has an attorney that can provide the guidance you're going to need after that turnover meeting. I mean, I have I won't call it standard, but it's standardized. It's roughly a 10 to 12 page letter, maybe 15 sometimes, depending on the community, that basically outlines everything that the association should be looking into after the turnover to protect itself from the developer. Now, that doesn't mean the developer did anything wrong. It's making sure they didn't before you just let it go.
So we have a question is, if you have your turnover election in June, we passed the 90 in December 25th. Do you still hold the annual meeting in November like in the past, or do you change it? And how does that affect the term of officers?
So realistically, I don't care if it's November or June. You just look at your bylaws and see what they say, and they'll dictate when that meeting is supposed to occur. They'll also dictate, yes, okay, you're supposed to have a 1-year term. My opinion is the date of the election governs over how long the term is supposed to be. So I would take a look at your bylaws, see when that meeting is supposed to occur each year, and hold it. And if you've already passed it, because I know a lot of people will ask, well, we were supposed to have our meeting in November. It's now the end of April and we never did it. What are we supposed to do now? You have the meeting. The terms are supposed to be up. You have the meeting, and you might have an expectation and understanding that anyone that gets elected during this meeting is going to have a 6-month term, so that you can correct going forward and hold the meeting when it's supposed to be in the future.
Well, Alan, with all the freezing over, we got the show done. We got everybody's questions in the chat line answered. We've got all these new people on TikTok watching the show. Tell people again how they can reach you.
Sure. Well, again, my email address is AS, meaning Alan Schwartzide, at KBR, K Bender Rembaum, law.com. as@kbrlaw.com. And again, that phone number to reach any of our offices is 1-800-974-0680.
Alan's with us the last Thursday of every month, and we're on from Monday through Fridays. Please check our show out, and I promise you I'll get this TikTok stuff done. Alan, you're always the best, bro. I thank you so much.
I appreciate it. I won't tell my partners you said that, but thank you very much. And thank you to everyone for listening.
We'll see you next month. That's Alan Swartzide. Thanks, Alan. That's going to do it for us today. Wow, what a show. It's a lot different when you're on TikTok because you've got to, I'm answering phones, I'm answering emails, and thank God I got a great producer in Juan. That's going to do it for us today. We'll be back again with you tomorrow at 2:00 Eastern Time with more Ask the Experts.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.